Don't stretch in front of the bench, Mr. Jesse. Okay? Okay, now, Mr. Okay, we're in session of cause number 329-154, case of style of state of Texas versus Jamal Fitzgerald Jesse. How you doing, Mr. Jesse?
Good, how you doing?
I'm doing fine. Thanks for asking. Now, Mr. Jesse, your attorney is Mr. Christopher Bynum. Have you been in contact with Mr. Bynum, or has Mr. Bynum been in contact with you?
No, I called his office and to, like you said, to let him know that he's gonna be my lawyer. And I guess the secretary, whatever, all she said was he knows and he'll be in contact with you when he needs something or whatever. And I haven't got a call or anything yet.
How long has that been?
Since I came to court.
What date? What was, hold on, we're gonna find out. What date did he last come to court? Did we check?
June 7th, June.
When was the appointment made? June, July, August, and you hadn't had no contact with him, none whatsoever? Okay, now, Mr. Jesse, what we're going to do, we're gonna do an order to rescind. We're gonna appoint you another attorney,
Okay, thank you.
okay? And let's see. Okay, now next on the list. Okay, the next person on the list. Order rescind. Is Mr. Antoine Freeman.
Antoine Freeman.
Yes, our court coordinator will give you all the information on how to contact Mr. Freeman. Mr. Jesse, sorry for your inconvenience. Stand on the X in front of our court coordinator on the end. She'll give you your reset date. And once you get your reset date, you'll be free to go and you have a blessed day.
You too.
Thank you. Xavier Bertrand. We're in session in two cases. It's on the motion to revoke probation docket. Both cases are styled Xavier Keandre Bertrand. And it's cause number 315738 and cause number 329590. Mr. Bertrand, how are you doing?
All right, how are you?
I'm doing fine. Now, Mr. Bertrand, you are represented here by Mr. Christopher Bynum, is that correct?
Yes, sir.
Now, was Mr. Bynum hired or retained? I mean, appointed?
Appointed.
He was a court appointed, okay. Now, could we find out when Mr. Bynum was appointed on these cases? April 23rd. Have you been in contact with Mr. Bynum?
No, sir.
Have Mr. Bynum been in contact with you?
No, sir.
Okay. Since April 23rd. Okay, so Mr. Bertrand, the court is going to do an order to rescind in both your cases. In essence, Mr. Bynum will no longer be in your case, on your cases, and we're going to reappoint you another attorney.
Okay.
Okay, and that next attorney that's on the list is named Giles Cole. Okay, Mr. Bertrand, once Mr. Jesse finish there, you're gonna go stand in X in front of our court coordinator. Once you get your reset and your appointment for your new attorney, you'll be free to go and you have a blessed day. And thank you for your patience and sorry for your inconvenience. Okay, Mr. Jesse, you have a safe trip.
Thanks.
And you be blessed and sorry for your inconvenience.
You too. It's all right.
Oh, let me do this here. Sean Kemper. Okay, we're back in session. And we have two cases, cause number 323-662 and cause number 330-236. Both cases are styled the state of Texas versus Sean Orlando Kemper. We have Mr. Kemper who is present, and we have Mr. Kemper who is present with his attorney, Mr. Todd Overstreet. Now, Mr. Kemper, prior to the court going into recess, the court swore you in, is that correct? And Mr. Overstreet, your attorney, waived the record, is that correct?
That's correct.
All right, now we're back in session with this particular case, cause number 330-236. And the information in this case alleges that on or about April 27 of 2019, in Jefferson County, Texas, Mr. Kemper, that you allegedly committed the offense of obstructing of highway passageway. This information further alleges that was further presented that during a period of July 23rd, 2019 until July 26th of 2019, and the information did y'all, are we gonna do anything with that information? Or?
That, Your Honor, that's what we're gonna ask the court. I didn't know if there's any way to write that in to amend it. Or
Well, you can amend it. I mean, if that's what you want to do, a trial amendment, you can just write in, and the other thing is, I have, a case here, ex parte, Eric Hyman, and that's, 456 Southwest Third, 159, states that a defendant had a right to forfeit his, limitation defense to the charge. In this case, it was tampering as part of a plea bargain agreement. So if that's the case, I mean, I wrote here on the, plea admonishments, if he desired to forfeit his, statute of limitations defense, that the defendant forfeits his statute of limitations defense. And if that's the case, he could initial this here, as well, and that's pursuant to ex parte Harmon.
Yes, Judge, I actually know that case too. And I think they actually, if I'm not, maybe I'm mistaken, when they refiled this, it would have, I thought it would have been actually inside the 2 years, no, because it was July. Did y'all refile it?
Let's see.
Yeah, I thought they just kind of snuck it in there, but I've read that case.
Okay, because they put that on there. Let me see, April, when was it filed? Y'all got a file date? Oh, July 26th. That's July 26th. That was, no, it was after the, it was, yeah, it was a April, May, June. It was 3 months after.
Okay. Yeah, then we would, I read that case. I'll explain to my client, technically they could, the statute of limitations would be told on the DWI, so they could just turn around and refile the DWI if they wanted to. If this is pursuant to a plea bargain, they're going to dismiss it. But just so you understand that we would be waiving any challenges that we might have appellate-wise to a statute of limitations bar on the new filing. Are you okay with that? As part of the plea bargain? Does that make sense? Okay.
Okay, so let me, wrote the language, you could just initial.
Yes, sir.
Okay, thank you. Okay, now, in cause number 330236, the state is having information that alleges that on or about April 27th of 2019, that you committed the offense of obstructing a passageway, obstructing of a highway passageway. And the state further presents that during a period of July 23rd, 2019 until July 26th of 2019, and information charging you with, now, right there, you're gonna make with a DWI offense, where you say instead of the above offense?
Yes, Your Honor.
Okay, so do I don't have a paper copy of did you print off his information? Yes. So we just try to cover it both ways. Man.
Do you have any questions? Make sure you know what's going on here. We don't charge for that.
You just want me to write it?
You could
Mark it
I
up?
think you can mark, if you want to mark it and just put a line that's going
Arrow,
where it's gonna go, because I don't think you have enough space unless there's an area, unless you can white it out. I don't know how you're gonna do it. You're gonna scratch through it, I guess, would be the best way. Attorney Jones, we'll be with you in a minute. Okay, I guess you're gonna have to provide amended information. You have to, that's, because that's gonna, we're gonna have to e-file that.
Correct.
Should it be initial?
That's going to be on the instruction, correct, Judge?
Yes.
Okay, so we would waive any objections to the amendment.
Okay, you have no objections?
No objections.
Okay, so let me just read this information again. Now, this is an amended information. And in the amended information, the state alleges that on or about April 27 of 2019, that you committed the offense of obstruction of highway passageway. The state further presents that during a period of July 23rd of 2019 until July 26th of 2021, an information charging the offense DWI with a breath alcohol concentration level of 0.15 or more was pending in a court of competent jurisdiction, to wit, cause number 323662 in the county court at law number 2 of Jefferson County, Texas, styled the state of Texas versus Sean Orlando Kemper. Now to this amended information, Mr. Kemper, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, now, Mr. Kemper, I have before me a document that is titled the misdemeanor plea admonishments. Mr. Kemper, do you recognize this document?
Yes, sir.
And on page 2 of this document, Mr. Kemper, there's a paragraph that was handwritten and that states, the title is Forfeiture of Statute of Limitations Defense. The defendant waives his statute of limitations defense. I'm gonna say in the above case. Above, okay. Okay, let me just read this in all initial as well. The statute limit, forfeiture of statute of limitation defense. The defendant. Okay, the defendant forfeits his statute of limitations defense in the above and numbered cause. And there are a set of initials, my initials, and then there's 2 sets of initials here on the side. And the first set of initials, Mr. Kemper, is that your attorney's initials? That's your attorney, that's your initials, Mr. Overstreet? And the second set of initials, SK, are your initials, is that correct?
Sir.
Now, there are also a set of initials down here at the bottom of this document. And it's on a line next to a box that's checked nolo contendere, which means no contest. Are these your initials?
Yes, sir.
On page 3 of this same document, Mr. Kemper, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, Mr. Kemper, this document is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Kemper, do you recognize this document?
Yes, Yes, sir.
Is that your signature above the line that's titled defendant?
Yes, sir.
There are two boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you are waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
I have another document here. This document is titled to discovery certification. Mr. Kemper, do you recognize this document?
Yes, sir.
Is that your signature above the line that's titled defendant?
Yes, sir.
There are, Mr. Kemper, prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Kemper, are you a U.S. citizen?
Yes, sir.
State, I have before me state's exhibits number 1. State, you will also like to offer state's exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Any objections, Mr. Overstreet?
No, sir.
No objections, state's exhibits number 1 and 2 are admitted. Mr. Overstreet, you have advised and counseled Mr. Kemper. Is there any evidence? Computer just went out. Okay, is there any evidence that Mr. Kemper is mentally incompetent to stand trial?
No, Judge, just the opposite. He is mentally competent, understands the full nature of the newer charges against him and the full range of punishment therein.
Okay. Mr. Kemper, your attorney, Mr. Overstreet, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay. Mr. Kemper, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's 180 days jail, probated over 15 months, $500 fine, 60 hours community service, victims impact panel,
Okay.
DWI repeat offender course, and drug and alcohol assessment.
Okay, Mr. Kemper. The state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail on this case because you will be placed on probation for 15 months. During the 15 months probationary period, you'll be required to pay a fine of $500 plus court costs of $342, which comes to a total of $842. You also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. Your total monthly installments that you would have to pay each month, Mr. Kemper, is $135. Mr. Kemper, will you be able to pay the $135 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service, attend a drug education class, submit to alcohol and drug urine screening at the discretion of our probation office, attend and complete victims impact panel, attend and complete a DWI education course. You will also be required to adhere to the other standard terms and conditions of this probation. Mr. Kemper, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Kemper, I'll follow the plea bargain agreement that you have entered into with the state. State, in reference to clause number 323662, the state of Texas versus Sean Orlando Kemper, which is the next case. What is the state's position on
Yes,
that?
Your Honor. The state has signed a dismissal on that.
Okay. Okay, Mr. Kemper, in clause number 323662, the state will be dismissing that case, and I'll be signing the dismissal in a few seconds. Now, Mr. Kemper, you're gonna stand on the X next to your attorney. You're gonna follow the directions of our clerk. And once you finish following those directions, Mr. Kemper, you'll be free to go, and you have a blessed day. And you have a blessed day as well, Mr. Overstreet.
Thank you, Judge. Good to see you.
All right, nice seeing you.
Thank you, Judge.
All right, you're welcome.
Hey, Daniel, can you add that dismissal, put it on the tablet for me?
Yes, ma'am.
You're talking on the plea form, plea agreement,
Oh, on the,
Yeah.
plea agreement.
Yeah. Just a second.
Hey, nice to meet you. Here's-
The 20.
What was that number?
it's 33.
No, the one,
Which one? The,
Your dismissal is printing off. She's gonna give you a copy of the
oh,
dismissal.
323662.
yes, ma'am, that's the dismissal one.
Can I use your right thumb? please?
Okay, Mr. Jones,
Yes, Your Honor.
we're getting the prosecutor down who's been handling that. He was here a few minutes ago and he stepped out, so we're trying to get him to come back.
I see, Your Honor. But Mrs. Tran, she said she's in the hospital, so I mean, I don't know if we need to reset. So that she
Okay,
can
well,
be here to
Okay,
after-
that's fine. We'll reset it.
Okay, thank you, Your Honor.
You want to just call us back? Just get back with us on a reset date.
Yes, Your Honor.
All right. Okay, you excused and you have a blessed day and stay
You too.
safe.
Yes, sir. Thank you. Have a great day.
All right. Mr. Augustus,
Yes, sir.
we made contact, at least we contacted the attorney's office, left a message. We haven't got a response. And so Mr. Augustus, give us a reset date. Mr. Augustus, what is it? Mr. Augustus, we're gonna reset your case, October 15th. And sorry for your inconvenience. Two, thank you for your patience. And we're gonna try to find out, why your attorney haven't responded. But anyway, your case is, what that date?
October 15th.
Okay, your case is gonna be reset to October 15th of 2021. Stay in contact with your attorney and your bondsman. Again, we apologize for your inconvenience and thank you for being patient.
If I
And
may
you-
speak, because I have because I'll be calling. First of all, thank you for giving me that information about my lawyer. But I had, while I was waiting, I wanted to apologize to the court and to you first and foremost for coming up before you again on his revocation. I sat before you now at 7 months of sobriety, and I also had a second chance at donating a kidney to my brother. I started 4 years ago with my father, and I have a second opportunity, and I have a prostate exam, MRI, and a colonoscopy, and my brother as well today. He should be getting some information back on his heart tap to see when we can make the decision to do the actual transplant. And so a lot of the dates that been changed been due to
Okay,
the procedures that I've been going through.
okay. Now, let me
Yes,
ask
sir.
you to see that date that we gave you, do you need it changed or anything?
Well, I like to have it a little later because, like I say,
Okay,
it's
okay,
kind of
we'll
be
do that.
going back and forth with,
okay, hold on a minute. I gotta get my court coordinator to come back in. We're gonna give you some additional time on that. And
Okay,
again,
and then also I do a lot of out of town work. I'm trying to. I sent some paperwork in. I had my bondsman send paperwork in if I can't get in touch with my lawyer to come and speak with you about changing the date. Sometime with work.
I'm gonna change that date right now. So once
Okay.
the coordinator get back in the courtroom, she had to step out for a minute. We're gonna reset your court date now. Thank you for sharing that with us. First of all, I always tell people this here: the road to recovery is not a sprint; it's a marathon.
Yes,
And
sir.
that just simply means that, it's, the difference between a short race and a long race. with a long race, you may get tired along the way. But if you get tired along the way, you should be assured that you have a support system of people that you can lean on. We have a program here in our court. We have a partnership with Spindletop. They have a program called ATAR, Addiction Treatment and Recovery. We also do work with OZAR, the local Drug and Alcohol Council, and any support that you need through our CSI program that I've had in place for since 2017, we can give you that support. But again, we'd like to commend you for taking the first step to recovery, and we would like to encourage you to stay on that journey. And also, we also like to be prayerful with you and your brother with him getting a transplant from you. Now,
Thank you.
okay, you're welcome. Now, Mr. Augustus, our court coordinator, is back here. Get extended about, let's give him a 90-day extension. November, okay, we're gonna reset it to November the 12th.
Okay, thank you.
Okay, and again, stay in contact with your attorney and your bondsman. And this will conclude your case. Again, thanks for being patient with us. And as I said earlier, we all praying for you and your brother, and that y'all have a match and a speedy recovery. And we also like to encourage you to stay on the road to sobriety.
Yes, sir.
All right.
Thank you.
Okay,
Yes,
you
sir.
excuse, and you have a blessed day.
You too.
Okay, you're welcome. What else we have? Let's see. Oops, you in Keller? Okay. Hmm? No. Is it a straight probation?
We changed it to deferred.
It's a 90 days deferred?
It's 6 months deferred. Yeah.
Oh.
So we just need to
gonna get it to you, the client. I'm gonna, that, at the end of the, plea, I'll have to go over that with her.
That's Miss Georgia just walked in.
Right,
Okay,
at the end of this. unfortunately, you won't be able to- No, can I ask something? If this is gonna be deferred, then she has to, she can't. do
well,
it for the term
well,
of
or if it's
probation.
deferred,
Yeah,
say, you by entry of order or judgment. It said by entry of order or judgment.
only during the time she's on probation. That's what I
Well,
understand.
I don't, to possession.
Because the deferred, once she finishes her deferred period. of
I mean, you
probation-
can advise her on, you can advise her as to,
Right,
I think that's what this says here in terms of the length of time for, that you cannot possess or purchase firearm ammunition, but your attorney will advise you on that,
Yeah, I
okay?
can advise you on that. That means while you're on probation, particularly, you can't own firearm, have ammunition. That's what it means. If this is deferred, you've got to complete your probation.
Okay, now let me go, yeah, I will go over it with you
Right.
at the conclusion of the plea. Now, Ms. Keller, okay, we're in cause number 329268, State of Texas versus Aaliyah Keller. Is that your full name?
Yes.
Ms. Keller, would you please raise your right hand? Ms. Keller, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Keller, how are you doing? You may put your hand down. How are you doing?
Good.
That's good. Ms. Keller, you're here represented by your attorney, Mr. Bruce Cobb. Mr. Cobb, will you be waiving a record in this case?
Yes, Your Honor, I will.
Ms. Keller, I have before me an information that alleges on or about March 31st of 2021, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of assault family violence. Ms. Keller, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Keller, how do you plead? Guilty, not guilty, or no contest?
Yes, sir.
No contest. No to resign for no contest.
Oh, no, no, sir.
Now, Ms. Keller, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Keller, I have before me a document that is titled Misdemeanor Plea Admonishments. Is it also labeled as State's Exhibit Number 1? Ms. Keller, do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Keller, there are a set of initials on a line that's next to a box that's checked no contingent, which means no contest.
Yes,
Or
sir.
did you place your initials on this document?
Yes, sir.
On page 3 of this same document, Ms. Keller, there's a signature at the top above the line that's titled Defendant. Is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
Is that your signature above the line that's titled Defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you are waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Ms. Keller, I also have another document here. This document is titled the Discovery Certification. Ms. Keller, do you recognize this document?
Yes, sir.
Is that your signature on this document?
Yes, sir.
Ms. Keller, prior to signing and initialing these documents that I've just mentioned, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer States 1?
Yes, Your Honor, and also like to offer states to the probable cause update.
Any objections?
No objection, Your Honor.
No objections. State's Exhibits Number 1 and State's Exhibit Number 2 will be admitted. Mr. Cobb, you've advised in counsel, Ms. Keller.
Yes.
Is there any evidence that she is currently mentally incompetent to stand trial?
None, Your Honor.
Ms. Keller, your attorney, Mr. Cobb, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation. Ms. Keller, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 6 months deferred probation, a $250 fine. The state waives any community service in this case, and anger management.
Do we have a affidavit of indigency? Ms. Keller, the state is offering that you serve 6 months on deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $250, and you will also be required to pay court costs. Now, the total fine and court costs comes to an amount of $542. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and attorney's fees of $250 each month. She doesn't have one? Is there a waiver, a magistrate's warning?
Just our PC information complaint and her security bond.
What-
How did I get appointed?
Yeah, when was his appointment made? Unless it was before we was doing these forms.
This case is from 2021.
What?
Mayor, can I ask my
Oh,
question?
well, hold on, no, just hold on a minute.
Let me go check something out.
Okay.
Yeah, hold on a minute. She needs to go check. Just hold on a minute. Mr. McIntosh,
No, you don't have to sign. No, I need to sign.
Mr. McIntosh,
This suburban contract needs to be, he said there's really not a choice in this county. Mr. Paul.
Hey, Judge, sorry, I was doing some office stuff. My apologies.
all right. Okay, Mr. McIntosh, I see here in Chastity Wells
Yes, Judge.
cases, apparently, you have filed two petitions. I think you filed an amended petition and then you filed it, I guess, as a new offense, as a new petition. And so, subsequent to that, you filed a motion to consolidate. Is that correct?
Yes, Judge. The problem is that we had accidentally submitted it as a new filing.
Okay.
The first, as far as this iteration of this case, the first time we accidentally filed it as a new filing versus an amended previous filing.
Right.
And so we then filed the amended filing, but then we had to consolidate the two so that way the clerk's record would be more clear.
Okay. Now, State, you have had an opportunity to look at the motion to consolidate.
Yes, Your Honor, we have, and state is not opposed to it.
Okay,
We understand it's essentially a clerical error. We're
Right.
Just trying to clean it up.
Okay, I'll be signing this motion to consolidate today, 27th. Now, and I guess, Mr. McIntosh, you're gonna be proceeding on the amended motion?
Yes, Judge.
Okay, I haven't, I need. I would have to look at it. Let's see. Go ahead on, and this is his motion to consolidate. I think it's just gonna be that one page that you're gonna actually e-file. let me look at this amended. Okay, I just need to, now what I can do is, let me do this. I need to take some time to look at the amended petition. We can reset it. I'll give you an opportunity to prove it up. We can do it next Friday or anytime that's convenient with your schedule, Mr. McIntosh.
Let's see.
Does anyone?
I will be in your court on Monday. I know Monday is normally a trial docket day, but it's still August. So I presume you're not doing any trials, but I don't know that to be certain. But if we could do Monday, as far as my schedule goes, that would be best for me.
Okay, just set it for Monday. Let's see, Monday, we got 3 dockets that day. Yeah, I think we got about 3 dockets that day. We got a trial docket, announcement docket, and a pre-trial conference docket. It might be a little.
Your call. If you would rather it not be Monday, Judge, I understand.
If you want to do it in the morning, then we're gonna be busy that day. But if you do it in the afternoon, we won't be. We should be finished with our things that we have set in the morning.
Okay. Would you mind if I zoomed in?
Oh, you talking about that afternoon?
Yes, Judge.
That's not a problem.
Okay. Yeah, we can do Monday, August 30th.
Okay, let's do it at say 1:30.
That's fine with me, Judge. Yeah, that works
Okay.
with me.
Okay, we'll do that. All right. All right, see you Monday at 1:30.
Thank you, Judge.
And you have a blessed day. Mr. McIntosh and Mr. Shearer, you have a blessed day as well.
Appreciate you.
All right, you're welcome. You're excused. Okay. Back on the record in cause number 329268, case of Style of State of Texas versus Aaliyah Keller. Now, Ms. Keller, previously, well, prior to the court going into recess, you entered a plea of no contest to the charge of assault family violence. You acknowledge that your initials and signature was on State's Exhibit 1, the misdemeanor plea admonishment. You also acknowledge that your signature was on the, let's see, trial court certification, the defendant's right of appeal. And you also acknowledged on the trial court certification that you understood that this is a plea bargain case, you have no right of appeal, and that you're waiving your right to an appeal in this case. You also acknowledge that you recognize the discovery certification and that was your signature on the discovery certification. The state announced its offer or the plea bargain agreement in this case. And that plea bargain agreement, I still haven't taken this off. Take up that 90 days that has to be taken off. Okay. Now, the state acknowledged that your punishment was 6 months deferred adjudication, and your fine was $250, and that they was waiving the community service in this case, and that you were also required to attend and complete the anger management course. Ms. Maxey, is that the state's offer?
That's correct, Your Honor.
And Ms. Keller, I'll just repeat, the state is offering that you serve 6 months deferred adjudication. In this case, during that 6 months deferred adjudication probationary period, you'll be required to pay a fine of $250 plus court costs. The fine and court cost comes to an amount of $542. You'll also be required to pay probation fees of $60 each month, a urinalysis fee of $15 each month. And you'll also be required to reimburse Jefferson County $250 for the appointment of a court-appointed attorney. Your total monthly installments that you will be required to pay in this case, is $235 each month. Ms. Keller, would you be able to pay the $235 each month? Okay, now, Ms. Keller, I have before me an affidavit of indigency that was filled out and signed on June 8th of 2021. Ms. Keller, is that your signature?
Yes, sir.
And Ms. Keller, I'll just get this to her, let her look at this here. Ms. Keller, I'll let you review that document. Is everything in that document true and correct to the best of your knowledge?
Yes.
Okay, and it is still current. You haven't had any changes, is that correct?
No.
Okay, so everything is the same. Now, Ms. Keller, on June 8th of 2021, based on your affidavit of indigency, the court found that you met the eligibility requirements of a court-appointed attorney, which basically meant that you was indigent. And so the court will also make that finding again today. The court is going to find that you are indigent, and pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the court costs, let's see. Okay. That's 542. Now, the court costs in this, the fine and court costs in this case, Ms. Keller, is going to be converted to 43 hours of community service. And that simply means instead of paying the fine and court costs, you will perform 43 hours of community service to pay off the fine and court costs. And the probation fee of $60 in this case will be reduced to the minimum of $25. Okay. So Ms. Keller, let me repeat. The state is offering that you pay a fine of $250 plus court costs, which comes to a total of $542. The fine and court costs of $542 will be converted to 43 hours of community service. And the probation fee of $6 will be reduced to $25 of probation fee that you would have to pay each month. And these adjustments or reductions here and conversions is a result of the court finding that you're indigent and pursuant to Article 42.15. Your fine and court costs will be converted to community service and your probation fee will be reduced to a minimum of $25. Now, you will still be required to pay the $15 each month urinalysis fee and the $250 court-appointed attorney's fees. Now, the amounts that you would have to pay in monthly installments is going to be reduced, and the probation department will make those adjustments for you. Now, Ms. Keller, you do not have any regular regular community service. However, the 43 hours that was converted from the fine and court costs will be community service that you'll be performing. And you'll also be required to complete anger management, and you will also be required to adhere to understand the terms and conditions of your deferred adjudicated probation. Ms. Keller, do you understand the state's offer and the adjustments that the court has made?
Yes, sir.
And do you think that it's fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Ms. Keller, I'll follow the plea bargain agreement that you have entered into with the state. The court finds that you're indigent and pursuant to Article 42.15 of Texas Code of Criminal Procedure, your fine and court costs of $542 will be converted to 43 hours of community service, and your probation fee of $60 will be reduced to $25 each month. Now, Ms. Keller, if you successfully complete the probationary period, the deferred probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure. Ms. Keller, you also have before you a document that is titled Model Ammunition on Ineligibility to Possess Firearm or Ammunition. Now, the ammunition basically is a warning, all right? So in accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you or warns you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code, Section 46.013A, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Texas Penal Code, Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of any antique or curio firearm manufactured before 1899, but only if The replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code, Section 46.02, unlawful carrying weapons. Penal Code, Section 46.04, unlawful possession of firearm. Penal Code, Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code, Section 85.026, warning on protective order. Now, Ms. Keller, a document that's been handed to you with the written ammunition is for your keeping. We ask that you please, in your time, if you can talk to your attorney about it. And at this time, Ms. Keller, we need you to stand on the X next to your attorney. You're going to follow the directions of this clerk. And once you follow the directions of our clerk, you'll be free to go, and you have a blessed day.
You can make sure you keep this.
Yeah, that's your copy.
So can I get your right thumb? Lift it up again. Try it again.
We're in session in cause number 326-166. Case of style of State of Texas versus Zacrease Johnson. Mrs. Zacrease Johnson was scheduled to be in court for the court's announcement document, which was scheduled at 9 a.m. on today's date of August 27 of 2021 in County Court at Law number 2 of Jefferson County, Texas. Mr. Zacrease Johnson's name was called at or about 9 a.m. by the court's bailiff at the courthouse door, and Mr. Johnson did not answer. Mr. Johnson has not appeared in court since the court has been in session since 9 a.m. And the time now is 12:20 p.m. on today's date. Mr. Bailiff, would you please call the name of Zacrease Johnson? Okay, Zacrease Johnson's name was just called by the court's bailiff at the courthouse door. Mr. Johnson did not answer. A reasonable time has passed to give Mr. Johnson an opportunity to appear in court for the court announcement docket, and he has not appeared. Therefore, State, do you have a motion?
The state would move for bond forfeiture at this time.
That motion will be granted. Mr. Zacrease Johnson's bond will be forfeited in cause number 326166, and a warrant shall be issued for his arrest. And this will conclude the calling of both the motion to revoke probation docket and the announcement docket that was scheduled in County Court at Law number 2 of Jefferson County, Texas at 9 a.m. on the day's date of August 27, 2021. Judge Terrence L. Holmes presiding. Everyone have a blessed